Picture this. You are standing at the kitchen window on a quiet Tuesday morning, looking out at the same garden you have tended for 30-odd years. The kettle has just clicked off, and the kitchen still smells faintly of last night's supper. A thought arrives, so softly it barely disturbs you, that one morning soon, you might not be the one standing here. Nothing dramatic happens at all. The light just shifts a little on the fence, and the morning quietly sits there like snow on a roof waiting to slide. If that ever lands with you the way it lands with me, please do me one small kindness today. If this channel is the kind of quiet company you would like to keep on a Tuesday morning like this, tap the subscribe button below and let me come into your kitchen every week for a gentle chat. There is no rush, no loud pitch, and no flashing banners at all, just a cup of tea and a few honest minutes about how to look after the things you have spent a lifetime quietly building up. The reason I want to have this conversation properly with you today is because there is a quiet truth almost no one tells you out loud. By the time most people finally get round to sorting out their important paperwork, it is rather often already too late for the documents to be signed. Not because the law is cruel and not because the system is unfair, but because most of the documents that protect your home require something that cannot be added later on, which is the simple fact that you still can in this life. That is the central idea behind everything we are going to walk through today, and I would like you to carry it with us right through to the end of our time together. The 8 documents every UK homeowner over 65 really ought to have in place are not complicated bits of legal jargon hidden in some solicitor's vault. They are plain, ordinary pieces of paper that you sign while you still have full voice, full clarity, and full capacity for making decisions about your own life. They are the things that quietly stand between your home being passed on with dignity and your home being fought over by people you love in a way you would never have chosen. Every single one of them follows the very same quiet principle, which is this: you must sign them while you still can in this life. Let me walk you through the 8 documents one by one, slowly and plainly, the way I would explain them to my own mum if she were sitting across the kitchen table from me with her second cup of tea. As we go, if anything I say resonates with you, I will gently remind you from time to time that subscribing is the simplest way to keep these calm conversations returning to your screen every single week. There is no clever sales trick to any of it, and no flashy promise about overnight reform. Just a quiet promise from me to you that every one of these documents is far more straightforward than most people in this country ever quietly suppose. Let us start with the one most people have already half heard about, and yet most UK homeowners over 65 still put off rather longer than they ought to. Picture yourself walking into your local solicitor's office on a Wednesday morning, the same one your late dad used for the house in 1972. You take a seat in the tired waiting room with the same floral wallpaper that has not changed since you were a child. The solicitor smiles at you from behind a desk covered in paper and asks you a few careful questions. Right there, in that quiet chair, is the moment to start putting your affairs properly in order for the people you love. This is the moment to sign the document that says exactly who gets your home, your savings, your jewellery, and your little bits of treasured nonsense when you die one day. That document is called a will, and it is the most ordinary piece of paper in the entire legal system today. Without one, the law decides for you, and the law does not know that you wanted the rose gold wedding ring to go to your eldest daughter, or that the oak sideboard ought to stay in the family for another generation. The mistake I see most often among ordinary British homeowners in their late 60s and 70s is a polite postponement, the quiet sense that making a will feels morbid or tempting fate, or something you only do when you are properly old in this country. The relief, when you finally do it, is honestly rather simpler than most people quietly expect. You sit down with your solicitor, or you fill in a proper online template from a reputable provider, and you sign your will in front of 2 witnesses who are not themselves named as beneficiaries anywhere. The named practical phrase to remember is this: safely stored, properly witnessed, regularly reviewed. You do not need a bank vault, and you do not need a fancy ceremony. You do need somebody you trust to know where the document sits, and a gentle review every few years as your family quietly changes around you. And here is the larger principle I would like you to carry back to the central theme for our morning together. A will does not protect your money. A will protects the people who love your money in this life. That is the kind of quiet, dignified protection you can only put in place while you are still the one sitting in the solicitor's waiting room with a cup of cold tea. If this conversation has so far been useful at all, would you consider tapping subscribe and letting me become a regular Tuesday morning visitor in your kitchen? Imagine your phone ringing one Wednesday lunchtime and your daughter phoning in a panic to say that dad has had a fall and is now in hospital. The high street bank will not let her pay the gas bill because her name is not on the account in the right way. She is sitting in the hospital car park with a debit card that has just been politely declined, and she has no legal right to touch any of your money at all. That, in plain English, is the exact moment the missing document would have quietly saved the day, and most ordinary families simply do not realize it exists in the system. That missing document is called a lasting power of attorney for property and financial affairs, often shortened by people in the legal trade to a simple LPA. In even plainer English, it is a single piece of paper you sign while you are well that gives a trusted person you choose in advance the legal right to look after your money, your bills, and your bank accounts if you ever lose the capacity to do it yourself. The trap that catches so many ordinary British homeowners is believing, quite understandably, that the bank will simply step in or that the family will sort it between themselves with a bit of common sense about it. They will not, because without this document properly registered, your accounts legally freeze the moment you cannot speak for yourself, and the entire system quietly grinds to a complete halt. The named practical phrase I would like you to write down and keep, perhaps on the front of your kitchen folder, is this: gov.uklp1f, £82 to register. That is the official government form number you need, and that is the fee paid to the Office of the Public Guardian to put your document into proper legal force across the system. You can fill in the form yourself, you can send it entirely by post, and for the straightforward cases, there is no requirement at all to use a solicitor in the matter. The principle we keep returning to is the same quiet one I mentioned at the beginning. If you would trust Margaret to pay the gas bill while you were in hospital, you should sign the LP1F while you are still standing at the kitchen window with the kettle in your hand and your mind as clear as a bell. Could I ask you to subscribe before we move on to the third document on our list for the morning? It is one small tap that lets me keep coming back with this gentle, ordinary chat you clearly care about. Imagine now that the hospital discharge team calls a family meeting and quietly tells you that your dad will not be able to go home, that he will need to move into residential care, and that somebody needs to make the proper decision in his name. Your daughter is in the room, your son is on a loudspeaker from a business trip in Spain, and your sister, who is not really the right person for this kind of thing, has just turned up with a Waitrose bag of grapes and a worried smile. Everyone is looking at each other, and not one of them has any clear legal right to say yes or no to the care plan. It is, sadly, a quiet kind of family chaos that no one wants on a Thursday afternoon. That is exactly the situation the third document on our list was built to prevent, and it is the one people most often forget about entirely in their planning. It is the lasting power of attorney for health and welfare, the sister paper to the one we just talked about together. In simple words, it is the document that says who speaks to the doctors and the nurses on your behalf if you cannot speak for yourself, and crucially, what they can and cannot consent to on your behalf. That covers everything from day-to-day washing and dressing right through to bigger medical decisions about treatment and where you will live. The mistake that breaks hearts in care homes up and down the country is the family member who is not legally allowed to authorize the care plan because the right person never got round to signing the right form in time. This is the LP1H form, and unlike the financial version we just discussed, it can only be used once you have actually lost mental capacity in a meaningful way. It does not let your son override you while you are still bright as a button and able to answer every question on the Today program. The default in this country is always to follow your own wishes, exactly as you gently express them. The named practical phrase to remember, and please write it down on the front of your folder today, is this: register both LPAs together, pay only once. When you send both forms to the Office of the Public Guardian in the same envelope, you pay the £82 fee for only one of them, and the second registration is free of charge entirely. A small saving for most households perhaps, but more importantly, a clean, tidy way to do both in a single calm morning at the kitchen table with a pot of tea on the go. The principle behind it all, the same quiet principle that runs through every one of these 8 documents, is that there are some conversations your family should never have to have without you in the room. This paperwork keeps you in the room even when your own voice cannot be there, and that is quietly worth a great deal more than the modest fee you will pay. If this is the first video of mine that has made you sit up a little straighter in your chair, would you consider tapping subscribe before we go any further this morning? Let me tell you about a woman I will call Margaret, although in real life her name was something a little different and her family asked me not to use it directly on the channel. Margaret was 71, lived in a tidy semi in Stoke-on-Trent, had been widowed for 4 years, and had a son called Andrew who visited every Thursday without fail for tea. Their routine was fish and chips on a tray, half an hour of test match special, and a gentle chat about nothing in particular before Andrew drove the short drive back home. Margaret was a quiet, proud, very ordinary kind of British woman, and Andrew loved her very much. Margaret had told Andrew over the fish supper more than once that she did not want to be kept alive by machines if her heart stopped one day. Andrew had nodded lovingly every single Thursday for at least 2 years because he genuinely thought he understood exactly what his mother wanted in her heart of hearts. Margaret never wrote any of it down anywhere in the house, not even on a slip of paper tucked into the kitchen drawer beside the tea bags. She thought the nodded agreement across the table was, in some quiet way, exactly the same thing as a signed piece of paper filed properly in a folder. She was wrong, as it turned out quite soon, and the difference cost her family something very gently awful to carry. One Sunday in February, Margaret collapsed in the bread aisle at her local supermarket and was rushed into resus by a very kind paramedic called Steve. Andrew was called to the hospital, still wearing the coat he had run out of the house in, and was asked to make the decision the doctors were about to make for him on the spot. He said no, because he knew in his heart what his mum would have said that very minute if she had been able to speak at all. He was told, very gently and very correctly, that without a signed document he could not make that call alone in the room. The hospital, quite rightly and in line with the law of this country, explained to Andrew that without a signed advance decision on Margaret's medical record, they could not act on a fish and chip shop conversation, however loving and well meant it had been. Margaret was resuscitated, against her own known wish, and spent her last 3 weeks on a ventilator in a ward that smelled of disinfectant and faintly of the bread aisle she had been shopping in that morning. Andrew now keeps a folder on his own kitchen table containing every single one of the 8 documents we are talking about today, one tidy sheet for each of the most important moments in a life. He keeps them in a clear plastic sleeve marked "The Plan" in his own handwriting. That is what one piece of paper can quietly mean in a life, and that is why point 4 on our list is so very important to ordinary British families going through these difficult moments. The document is officially called an Advance Decision to Refuse Treatment, sometimes shortened to ADRT, but most sensible people I speak to about it simply call it a living will. It is the very plainest of the 8 documents we are discussing today, and in many quiet ways the most important of all of them together. In even plainer English, an advance decision is a signed and witnessed piece of paper that says, very specifically and without any kind of wiggle room, which medical treatments you do not want if you become seriously ill and cannot speak for yourself in the moment. It might say that you do not want to be resuscitated if your heart stops for the 2nd or 3rd time. It might say that you do not want a particular form of life-sustaining treatment to be continued indefinitely if it has no realistic prospect of giving your life back to you. The wording is up to you, in your own calm voice on a quiet Tuesday afternoon at the table. The mistake that costs families the most quiet grief, beyond even any inheritance tax bill or any care paperwork question, is the soft assumption that doctors will simply know your wishes because you mentioned them once over a cup of tea in a busy kitchen. Doctors and nurses are wonderful, thoughtful, caring people, but they cannot and must not act on a cup of tea in this country. They can only act on a properly signed, dated and witnessed document that sits quietly on your medical record for the day it might be needed by them. The relief, when you finally do this one, is the greatest of the 8 documents we are discussing together today. You do not need a solicitor at all. You can write it yourself on plain A4 paper, sign it in front of one witness, ideally 2 witnesses, and give a tidy copy to your GP surgery so it can be uploaded onto your medical record by the practice manager. The named practical phrase to remember is this: on the record, on paper, in my own hand, while I still can. The principle we keep returning to is the very same quiet one, the same one I have been holding all morning at the kitchen table. The best gift you can ever give your children at the end of your life is the gift of knowing exactly what you wanted, written down while you meant it, in your own tidy hand on a quiet Tuesday afternoon at home. If the Margaret story made you pause for a moment in your chair, would you consider letting a friend, a brother, or a neighbor who is a little further down the road know about this channel by sending them this video? Now we move on to the fifth document, and it is the one most ordinary pensioners have never even been told exists at all in the system. Imagine that you have done almost everything right. You have made your will. You have signed both of your lasting powers of attorney. You have tidied up your advance decision and given a copy to your lovely local GP. You die peacefully at 83, and your family gathers around the kitchen table the next morning, ready to carry out your wishes as a calm, patient team. So far, so simple for everyone in the room. But then your daughter, who is the executor, mentions quietly that there is a generous death benefit of around £15,000 from your old workplace pension scheme that has not been touched in 25 years. There is also a small lump sum from the building society you banked with for 40 years, paid in every Wednesday morning by the nice man at the local post office. You always said out loud that you wanted those extra bits to go to your daughter because she has the children and the bigger mortgage to juggle each month at home. The trouble, in plain English, is that the pension trustees and the building society have absolutely no idea about that loving family plan because you never filled in the form that gently tells them where to send the money. That form is called an expression of wish, sometimes called a nomination of beneficiaries form, and it is the document that quietly tells the scheme administrators where you would like any lump sum death benefit to go in the end. Without it, the trustees will use their discretion, which usually means following the standard default order rather than your own wishes. The named practical phrase to remember, and please do write it down on the front of your folder, is this: get the form, fill it in, send it back. It takes about 10 minutes for most ordinary people once they have a cup of tea in hand. Most pensioners I speak to have never been told this particular form even exists, because it usually turns up in a brown envelope about 2 months after you join a new scheme, and then quietly disappears into the back of a kitchen drawer for the next 20 years without ever being read. The principle behind it all, the same quiet principle as before, goes like this in my own plain words. A will only covers the things that actually go through your estate. Pension pots and many life insurance policies do not go through your estate in the normal way, and they each need their own separate little instruction to the scheme administrator. If you have stayed with me this far this morning, can I ask one quiet favour, and that is to subscribe, so this calm Tuesday company can keep returning to your kitchen each week ahead. Now we come to the sixth document, and it is really two little pieces of paper folded into one quiet habit. Imagine your daughter, who you have just appointed as your executor, opening up your solicitor's letter 2 months after you have died one day. Inside is a single sheet of cream paper addressed to her by her first name, written in your very own handwriting, saying the things the will could not properly say out loud in its legal language. That document is called a letter of wishes, and it sits alongside your will as a kind, gentle guide to your executors for the difficult days ahead. It is not legally binding in the same way your will is, but it is read by sensible executors as the closest thing they have to a whispered conversation with you across the kitchen table of your own home. It costs nothing, takes about an hour, and it gives structure and clarity to years of unspoken family wishes about the things that really mattered to you. Now let us turn to the most practical of the 8 documents, the one that surprises ordinary homeowners the most in our experience. You may well own your house as what the land registry calls a joint tenant with your spouse, which feels lovely and romantic because it means the survivor of you automatically inherits the whole property. The trouble begins when the survivor themselves goes into care one day, because the whole property is then fully exposed to a future care home fees assessment by the local council in your area. The fix is the 7th document, the deed that simply changes ownership from joint tenants to what is called tenants in common, usually with a tidy declaration of trust setting out each person's share on paper. It is done using Land Registry Form SEV or via a quick letter from a solicitor, and it is one of those small legal changes that quietly protects half the house from being swallowed up by care costs years down the line in your area. The principle behind both of these papers is the same quiet one, because you are putting the rule of the road in place now while you still can, so that the people you love do not have to make the rules themselves when you cannot. Now we come to the 8th and final document on our list, and it is the one your family will be most grateful for in the week after you are gone. Imagine the first morning after you have died. Your daughter sits at the very same kitchen table you usually sit at, with a half-drunk cup of tea, and a list of about 30 things that have to be sorted that week. The house, the will, the bank, the dog, the post, the neighbours, and right at the top of that list in red pen, the funeral. Funeral costs have quietly crept up in this country, and it is not unusual now for a straightforward cremation with a modest service to come in somewhere between £4,000 and £6,000, depending on where you live in the United Kingdom today. The very last thing your grieving daughter should have to do in the week after you die is phone around funeral directors, comparing prices she does not fully understand in a moment of shock. The eighth document is the prepaid funeral plan contract, regulated since 2022 by the Financial Conduct Authority, which means there are now proper consumer protections in place for the first time for ordinary families. The named practical phrase to remember is this: choose a provider from the FCA register, pay a single fixed amount or a small monthly amount, and the cost of the agreed funeral is locked in at today's prices, even if prices keep quietly rising in the years ahead of you. The principle behind this last document is the same quiet one. You are doing the kind thing now so that the people you love do not have to do the hard thing later in life. Before I close, and before we land this quiet conversation properly, may I gently ask you one more time, with feeling. If anything I have said today is going to sit with you for a few days afterwards, will you tap subscribe to this channel so that you do not lose the thread of it? There is a new video like this one most weeks, all plain talk and no shouting, no flashing pitch, just the kind of quiet weekly company that ordinary British homes deserve in their kitchens. And if there is one person in your life who you know really needs to hear this, a parent, a brother, a neighbour who is a little further down the road than you are, please send them this video. Send it as a quiet kindness, not as a task at all, with a simple message saying only that you thought of them and wanted them to know. That, more than anything else, is the highest compliment this channel could ever be paid in this country. Let us come back now to the quiet central idea I set out at the beginning of our time together, the one I asked you to carry with us all the way through this morning. The 8 documents are not paperwork for paperwork's sake. They are the 8 small locks on the same front door of the home you have tended for 30 years. You put them in place while you still have the key in your pocket, while you still recognize the lock, and while you still remember which door it is that you are quietly protecting. They do not need to be grand, they do not need to be expensive, and they do not need to be signed by a fancy city solicitor in your life. They only need to be signed by you in your own calm hand, while you still can in this life. To keep that image simple and memorable for you, let me leave you with this small picture. Signing these papers is a little like leaving a small lamp on in the hallway before you go upstairs for the night. You do it quietly, you do it without any fuss at all, and you do it so that whoever has to come down those stairs later on in life finds the light on just where they left it for them. The kettle will click off again in your kitchen tomorrow morning, and the garden will be the same garden, and the same light will be on the fence at the back. The folder will be sitting open on the side, doing nothing at all until the day it is quietly needed, and what it will mean to whoever opens it first will be worth every calm moment you put into it today.